Good afternoon and welcome to our lunchtime webinar on compliance responsibilities in a proactive, efficient regulatory regime. I am Helen Venn. I am one of 4 managers within the supervision function. My focus is on thematic work. I've been at the SRA for 9 years now, and prior to that worked at the Serious Fraud Office, the Criminal Cases Review Commission, and in private practice as a criminal defence solicitor. I'm here today with 2 colleagues, Alex Elliott and Maria Walters.
Hello, I'm Alex Elliott. I'm the manager of firm-based supervision, which oversees the supervision of 11,000 firms. I've been at the Solicitors Regulation Authority for 12 years now, principally involved in conduct and regulatory investigations. Prior to that, I was a solicitor in private practice, dealing with family and childcare work and civil litigation.
And I'm Maria Walters, Operations Manager within the Authorisation function. Authorisation, as I like to see them, are the gatekeepers of the SRA. Our primary role is to authorise individuals and firms. I've been working for the SRA for just over 4 years, similarly to Alex, principally involved in conduct and regulatory investigations, moving into authorisation over a year ago. Prior to joining the SRA, I also worked within the financial services market for 20 years.
Thank you both. Well, we'll be giving a presentation this afternoon that will last about 45 minutes and we'll talk through various slides. You'll be able to download these slides from our website. At the end of our presentation, we welcome your questions and comments, which can be made by posting them in the questions and answer box at the bottom of the screen. This is one in a series of webinars which the SRA hosts. You can find recordings of this and other webinars covering various topics on our website. We're planning future sessions, so please do keep an eye on our website for details. For those registered with us for this live webinar, 1 hour's CPD can be claimed, and we'll give you details of the code at the end after the questions and answers. So, moving on, let me give you an overview of today's webinar. As you can see from the slide, we'll start by discussing the role of compliance officers. We'll look at a couple of case studies, move on to talk about how we envisage the relationship working between us, the SRA, and the compliance officer community. And finally, we'll talk through the nominations process. As I've said, we'll be taking questions and comments at the end of the presentation. So if I can now hand over to Alex Elliott.
Thank you, Helen. Before I talk specifically about the compliance officer roles, I want to set the scene for those roles and recent changes in how we regulate solicitors and their firms. The Legal Services Act 2007 brought about significant changes to the provision and regulation of legal services. The SRA has reflected those changes in our new handbook introduced in October last year and in our approach to the authorisation and supervision of firms and solicitors. But what does that mean in practice? Firstly, it means a move away from prescriptive and detailed rules, which can create a tick-box culture to compliance, towards outcome-focused conduct requirements. That means that you have flexibility in achieving the right outcomes for your clients, taking into account the way that your firm works and the type of clients that you deal with. Secondly, it means much more emphasis on a proactive rather than reactive approach, and risk-based, targeted and proportionate regulation. Key to that is the need to have a more constructive relationship with firms, where firms take responsibility for compliance and for achieving the right outcomes for consumers, and are willing to engage with the SRA. In part, this responsibility is encompassed in Rule 8.2 of the SRA Authorisation Rules 2011, which require firms to have suitable arrangements in place for compliance. In the case of sole practitioners, this is set out in Rule 4.7 of the SRA Practicing Regulations 2011. The guidance notes to the rules set out common areas that managers will want to consider in terms of those compliance arrangements. The relevant rules go on to require firms and sole practitioners to have a compliance officer for legal practice, known as the COLP, and a compliance officer for finance and administration, a COFA. These are statutory roles that are required for licensed bodies, i.e. alternative business structures, under the Legal Services Act. In the Act, such bodies must have a HOLP, a Head of Legal Practice, and a HOFA, a Head of Finance and Administration. Today, for our purposes, though, I'll just use the terms COLP and COFA. Regardless of the size or nature of the firm, or the type of work undertaken, all firms are required to have compliance officers. These roles are at the forefront of compliance in our new approach to regulation and enable the SRA to be outcome-focused and risk-based with a legal community of over 11,000 firms. We've recently published research that looked at firms' attitudes to compliance and the outputs of that underline the anticipated benefits of compliance officer roles. The purpose is to create a firm-wide culture of compliance, and the role holders will be the focus point in firms, responsible for a systematic approach to compliance. They will ensure that you and your firm have systems and controls in place to enable you to comply with your regulatory requirements. This will help firms to focus on better compliance, better financial management, and better risk mitigation. We expect managers in firms to be satisfied that the individuals that they are nominating have the right skills and experience to undertake the role in the context of their particular firm. Importantly, firms must have suitable arrangements in place to ensure that its compliance officers are able to discharge their duties, as well as practical arrangements such as having adequate time and resource. This means a change in mindset so that managing risk and compliance is seen as everyone's job in the firm. In a recent speech, Samantha Barris, the Executive Director of Supervision, Risk and Education, reinforced the message that compliance officers in firms would not be sacrificial lambs and that responsibility still lies with the senior managers. She said that it is the role of the COLP, in particular, to be responsible for taking reasonable steps to put in place systems and controls for good compliance in the firm and ensuring that firms actively engage in relation to the principles and outcomes, but that those leading the firm are still absolutely responsible. A copy of Samantha's speech is available on our website. Despite the new compliance officer roles, our focus in the delivery of risk-based proactive regulation will still be on the firm and those responsible for running the firm. The appointment of compliance officers doesn't absolve managers from their responsibility for compliance. Final responsibility rests with the firm and its managers for ensuring compliance with the SRA's regulatory arrangements, having suitable systems for ensuring compliance, and putting in place suitable arrangements to ensure that the compliance officers are able to discharge their duties. In particular, managers will need to consider the following. Do the compliance officers have sufficient resource, time and access to fulfill the role? This is not just a job title, and firms will need to consider how the compliance officer role sits alongside other duties. Will the COLP and COFA be sufficiently empowered within the firm and equally adequately protected in undertaking the role? And are there clear lines of accountability and reporting? Remember that outcome 7.2 of the handbook means that it's the responsibility of the firm and its managers to have appropriate systems and controls in place to comply with the requirements of the handbook. Outcome 7.3 requires firms to identify, monitor and manage risks to ensure achievement of the handbook requirements. So managers cannot absolve themselves of their responsibilities through the appointment of compliance officers. Right, we're now going to have the first of our polling questions in the webinar. The question is, how would you like to receive information about the COLP and COFA roles? By email, telephone contact, through our website, by post, or at roadshows and seminars. We're interested in how you'd like to receive information from the SRA in relation to the roles and want to make that as accessible for you as possible. We've recently published lots of information on our website, and we know that lots of you have been accessing that.
So we can see that you're voting now. The preference is very much in favour of email. However, this is the first of 3 polling questions, and you'll note that we asked, as well as questions and answers at the end, we'd like to hear your comments. We review the information, and we'll then look at how we can best engage with compliance community and firms. But at the moment, over 90% or around 90% of the people listening would prefer email contact. I think voting's still continuing. We've got some people who would like to look at the website, a few people interested in postal and road shows, but the minority of people are looking at telephone contact, but very much it's email contact that's everyone's preference, so we'll take that forward. I think voting is going to close now.
Okay, thank you. We'll now move on with the next slide. So let's turn now to the specific requirements and responsibilities of the roles, dealing first with the COLP, Compliance Officer for Legal Practice. Rule 8.5b of the Authorisation Rules and Rule 4.8b of the SRA Practicing Regulations identify who can be a COLP. Firstly, the individual must be a manager or an employee of the firm. A manager means the sole practitioner, a partner in a partnership, a member of an LLP, or a director of a company. An employee is defined in Chapter 14 of the Code and includes both staff employed under a usual contract or individuals engaged under a contract of services. Secondly, the COLP must be one of the following. They need to be either a lawyer of England and Wales, a registered European lawyer, or an individual registered with the Bar Standards Board under certain EU regulations. They must also be authorised to undertake one or more reserved legal activities in the firm as defined in Section 12 of the Legal Services Act. Thirdly, the individual must have sufficient seniority and be in a position of sufficient responsibility to fulfil the role. So firms will need to consider the governance and management structures and consider whether the individual has sufficient authority within the firm to get buy-in, to create that important firm-wide culture of compliance. Firms will also need to join up reporting lines for any existing staff with risk and compliance responsibilities. The fourth requirement is that the person is suitable to carry out the duties of the role. The suitability test, which is available on our website, applies to all nominations and ensures that individuals being nominated by firms are fit and proper and do not pose a risk to the public or the profession. In considering nominations, the SRA will take account of any criminal convictions, the behaviour of the individual, financial probity, and regulatory history. For example, it's unlikely that we consider an individual as fit and proper if there's evidence of behaviour which is dishonest, discriminatory, or involves an abusive position unless exceptional circumstances apply. There are additional requirements in the suitability test for authorised role holders, which compliance officers are. This includes, for example, whether the individual has been removed or disqualified as a director. I'm going to turn now to the responsibilities of the Compliance Officer for Legal Practice. The duties of the COLP are set out in Rule 8 of the Authorisation Rules. The equivalent duties for the head of legal practice in a licensed alternative business structure are in Section 91 of the Legal Services Act. Essentially, the responsibility of the COLP is to embed regulatory compliance within the firm. But what does this mean in more detail? Firstly, the COLP must ensure compliance with the terms and conditions of authorisation, unless those relate to the Solicitor's Accounts rules, in which case responsibility is with the COFA. Secondly, they must ensure compliance with any statutory obligations of the firm and its staff in relation to the carrying on of the activities it is authorised for, in effect, the provision of legal services. Both of these are proactive responsibilities, requiring the COLP to work with all staff across the firm to ensure compliance. This may be through a compliance plan or various systems and procedures, perhaps already in place in the firm. By way of example, these could include a system for ensuring regulatory deadlines are not missed, such as the filing of accountants' reports, a structure for the development and training of staff on a regular basis, a system for monitoring, reviewing and managing risks, such as a risk register, and appropriate systems and procedures for compliance with undertakings, conflict checks, etc. Thirdly, the COLP must record any failings to comply with the above and to make those records available to the SRA if requested. The managers and the COLP will need to consider how such failings are recorded and any reporting within the firm itself. In relation to these duties, the COLP must take all reasonable steps to comply. This acknowledges that there may be circumstances where it isn't possible for the COLP to comply, and this will be viewed objectively by the SRA. Finally, the COLP must report any failings to comply to the SRA, and we'll deal with this in more detail later. Let's turn now to the COFA role, the Compliance Officer for Finance and Administration. In terms of who can be the COFA, the position is the same as for the COLP, save that they are not required to be a lawyer. So they must be a manager or employee of the firm. They must have sufficient seniority and be in a position of sufficient responsibility to fulfill the role, and they must be fit and proper to carry out the role. So the suitability test applies as before, although as you would expect, there's greater emphasis on the financial probity of the individual. This means that unless there are exceptional circumstances, the individual is unlikely to be considered fit and proper if there's evidence that they cannot manage their finances properly and carefully. For example, they've been declared bankrupt, have entered an IVA, or had county court judgments made against them. This will also be the case if there's evidence that the individual has deliberately sought to avoid responsibility for their debts, or there's been dishonesty in relation to the management of their finances. There's no specific qualification requirement for COFAs, but they must have an understanding of the Solicitor's Accounts rules. To be in a position to undertake the role, the COFA must have access to all accounting records. A common query in relation to the COFA is whether the person can be a COFA at more than one firm. For example, individuals that assist firms with their accounts may provide services to more than one firm. Firstly, this will depend on whether they fall within the definition of employee. And secondly, firms will need to consider if they have adequate time and resources and are sufficiently senior within the firm to fulfill the responsibilities of the COFA. One thing that firms may wish to consider is whether the same person can take on the role of both the COLP and the COFA if they are a lawyer. This is allowed under the rules, but again you'll need to consider if the person will have adequate time and resources to fulfill the responsibility of both roles. Let's now look at the responsibilities of the COFA. The COFA is responsible for ensuring that all managers and staff comply with the Solicitor's Accounts rules. This will include regular checks of the accounts and accounting systems, reviews of files and ledgers, and systems for monitoring, reviewing and managing risks that impact on compliance with the accounts rules. The COFA will need to make sure that there are appropriate accounting procedures in place, including proper systems and authorities for payment from client account. The COFA will need to be in a position to ensure that any breaches of the accounts rules are remedied promptly. Again, the role should be seen as proactive and working with all staff in the firm. This may include, for example, revising financial or accounting policies and procedures, publishing key information on finances and common questions to staff, or identifying key risks in relation to compliance with the accounts rules. The responsibilities of the COFA in terms of recording and reporting breaches are the same as those of the COLP, and we will deal with that in more detail next. I'm now going to hand over to my colleague Helen Venn, who's going to talk about reporting.
Thank you, Alex. So moving on now to reporting, what to report and when. As set out in Rule 8.5 of the authorisation rules, breaches that are material must be reported to us as soon as reasonably practicable, and a material breach may be a single matter or a pattern of failures or issues. There isn't an all-encompassing definition of material breach, nor a prescriptive list, but in deciding what amounts to a material breach, you can see the types of issues that need to be taken into account. So, for example, you'll want to consider the detriment or risk of detriment to clients, the extent of any impact on confidence in the practice or in the provision of legal services, the scale of the issue, so was it an isolated incident, and say the overall impact on the practice, clients and third parties. These considerations are referred to in the guidance notes to Rule 8. Compliance officers will want to take account of these in deciding whether a breach is material. Officers may also want to consider if the matter was an innocent mistake or perhaps inadvertent. Was it discovered promptly and corrected without delay? Although it's important to remember that the remedy of a breach will not necessarily avoid the need to make an immediate report. If in doubt, firms and their compliance officers should contact the SRA. We will always make it clear if the issue is one that does not need to be immediately reported to us. The requirement to report as soon as is reasonably practical also applies to non-material breaches, and these shall be taken to have been reported as soon as reasonably practicable if they are reported to the SRA in accordance with Rule 8.7a. That is, in the annual information report. In addition, there are other reporting requirements, so remember that a firm must notify the SRA as soon as it becomes aware of any changes to relevant information about itself, its employees, managers or interest holders, including any non-compliance with the rules or any conditions on the body's authorisation. So to summarise then, compliance officers will need to have a system to record failures to comply, to monitor overall compliance, to assess the effectiveness of systems, and to be able to comply with the duty to report breaches which are material, including those that are material because they form a pattern of breaches or failings. For further information, the SRA website is an extremely useful resource, and towards the end of this webinar, Maria Walters will be giving you the website address, which gives information for COLPs and COFAs, and an email address for compliance officers. Firm managers and those that are nominated for compliance officer roles who wish to seek advice can also call the SRA's ethics helpline or the contact centre, and again this information will be given towards the end of this webinar. You will also probably be aware by now of other organisations providing information and advice. For example, you might want to have a look at the Law Society website, where there is currently a compliance officers page. Other organisations are also providing courses, information and helplines for COLPs and COFAs, and also for people within a firm who have regulatory responsibilities. Now, if we could move on to another polling question. This is the second of 3 polling questions. We stress within the SRA that constructive engagement is key, and therefore we're seeking your views on areas around communication. The question is, what mechanisms would you like to see in place for reporting material breaches? And the options we give are central portal or email, direct to a supervisor, there's supervisors sitting within the supervision function, or any other ways that you'd like to report. And remember, again, we've stressed that in addition to questions and answers at the end, we'd also really like to receive any comments you have so that we can take that on board. Currently, voting is open for the mechanism you'd like to see in place for reporting material breaches. Central portal email is slightly preferred, but direct to a supervisor at the moment is about 40%. The figures change as people vote. And it's now becoming about 50-50 between central portal email and direct to a supervisor, which is interesting. We'll certainly take that into account. Within the supervision function, our supervisors do contact firms direct, telephone in the first instance. Remember also the reference earlier to the ethics helpline and the contact centre.
It's interesting, Helen, that when the poll first opened, the vast majority were suggesting they'd like to report through the central portal or email, but that's now changed, and actually it's now 53% of individuals saying they'd rather make those reports direct to a supervisor.
I think we're very interested today that there are currently 229 attendees. We're very interested for direct feedback and comments, perhaps suggestions. In relation to this polling question, nobody has put other, so there's no other reporting mechanism you'd like to see in place. But as we go through the webinar, if you think of any other mechanisms you'd like to see, please do post that and we can take that back. So thank you. I think finally, as Alex has confirmed, 56% would like to make a direct report to a supervisor and 44% central email portal. Thank you very much. If we move on now, it's useful always to look at some practical case studies. So let's do that now. You're a partner in Firm A and have been for 5 years. You've taken on the role of the Compliance Officer for Legal Practice, so the COLP. Your firm undertakes a mixture of private client conveyancing and personal injury work. You discover from a member of your team that one of your partners in the private client department has not been dealing with correspondence on one of his files. It's a probate matter. You speak to the partner, who admits that the client has complained about nothing having happened on the matter for some time. Your colleague hasn't been working on the file, nor has he responded at all to the complaint. He says that he hasn't been able to deal with the matter due to pressure of work. You review the file and note that the matter has not been progressed for just over 5 months. Your view is that no loss has been suffered by the client and you deal with the client's complaint. So, what action would you take, and would you report this to the SRA as a material breach? Well, we'd suggest you start by asking yourself some questions. You may want to ask, is this an isolated matter, or do you need to conduct a wider review of files across the firm or files across that person's workload? You've established that there's no loss or detriment to the client, but what procedures and systems may need to be reviewed as a result of this matter? And what about your colleague? How do you deal with that? What do you need to do? Answering some of those questions will lead you to assess whether this is a material breach, and whether it is or not may be influenced by wider investigations across the firm. If this was a one-off incident with no impact or detriment to the client, as you've assessed, it's unlikely to warrant immediate report to the SRA. If it was just one in a series of matters with lengthy delays by your colleague, or there was significant adverse impact to the client, it's likely that it would amount to a material breach. Please do remember, if in doubt, contact the SRA. Let's look at another example. In this scenario, you're the Compliance Officer for Finance and Administration, the COFA. It's a 3 partner firm, so a small firm. In accordance with the reporting procedures that you've established, the cashier explains to you that they've been unable to pay the firm's invoices because the firm has exceeded its overdraft. You are aware that the overdraft facility has been exceeded on a number of occasions, but the bank is now refusing to extend further. You approach the managing partner and the COLP to discuss the matter, since you are concerned that the firm is in financial difficulty. The managing partner tells you that this is a temporary cash flow problem and there is no necessity to report to the SRA. So do you report or not? Well, in deciding whether the matter is reportable, you may wish to consider some of the following questions. So how long has this issue been ongoing? How severe is the problem? What is the level of the overdraft? Are clients' interests at risk? And in particular, is there a risk to client money? Can you say that you're being open with the SRA if you keep this information to yourself? Think about whether the managing partner is trying to prevent you from reporting, or are there funds due in from another source that would ease the cash flow problem and the managing partner is aware of this? So is there other relevant information that you're not aware of or that you are aware of? Would anything support the managing partner's explanation? So your answers to these questions and others will influence your view as to whether the breach is material and must be reported to the SRA now. Again, remember, if in doubt, please do contact us. So I hope these case studies have prompted you to think of matters such as, have you set up a system or templates for recording breaches? How will you monitor breaches at the firm? Do you have a whistleblowing policy? What training have you given? Or will you be giving training to staff in relation to whistleblowing? Are there any other employment or disciplinary issues to consider in relation to breaches? How will disputes about whether a breach is reportable or not be resolved? And you might want to consider how you document discussions and decisions reached. So moving on now, I'd like to talk about the relationship between the SRA and compliance officers. At the risk of repeating myself, or repeating ourselves, the compliance officers in a firm are the formal focus points for compliance. They are not sacrificial lambs or scapegoats, so that others within the firm, particularly the senior managers, can absolve themselves of their responsibilities. If it did work that way, the regime would fail its most important test, and that is the creation of a firm-wide culture of compliance. This isn't just about having a particular point of contact with each firm with whom we can share particular thematic or firm-based activity. We hope that at least in part this is a community which, because of its heightened regulatory awareness, is one which we can have a particularly productive and broader regulatory engagement with, and that will support our own development as a regulator. We are focusing, as I said earlier, and in the polling questions, on constructive engagement and on being transparent, and that needs to be mirrored within firms. So remember Chapter 10 in the Code, headed you and your regulator. This requires cooperation with the SRA, and there are then some 13 outcomes to be achieved. These include compliance with all reporting and notification requirements in the handbook, outcome 10.1, and outcome 10.4, prompt reporting of serious misconduct by any person, the firm, or any employee of the firm. There are also a number of indicative behaviours which might be indicators of compliance with the outcomes. These include indicative behaviour 10.1, actively monitoring your achievement of the outcomes in order to improve standards and identify non-achievement. Also active monitoring of financial stability and notifying the SRA if the firm becomes unviable. That's at indicative behaviour 10.2. Notifying of serious issues as a result of monitoring and producing a plan for remedying issues identified, indicative behaviour 10.5, and at 10.10 having a whistleblowing policy. So you'll note that Chapter 10 of the Code starts by referring to a general obligation to firms and individuals to report serious breaches promptly to the SRA, whereas the COLP and COFA need to report material breaches and as soon as reasonably practicable. Well, in practice, there is no distinction between material and serious, and no difference between promptly and as soon as reasonably practicable. The firms and the COLPs and COFAs need to exercise common sense and judgment on what matters need to be raised immediately with the SRA and those which don't. And again, remember, if you have any doubts, then please do contact us. We're going to move now on to our third and final polling question. Again, we're looking at how you wish us to engage, how you wish to engage with us. So polling question 3 asks, how do you think the COLPs and COFAs should feed back to the SRA in relation to the impacts of OFR and supervisory engagement? And the options are, not dissimilar to our last polling question, direct feedback to supervisors, feedback questionnaires and surveys, email and website. Again, we really value your views. We want constructive engagement to be fundamental to us as an organisation, particularly to us in supervision. I've made reference earlier to the fact that in supervision, our first point of contact with you will usually be by telephone. We'll normally be picking up the phone. We can then introduce supervision as a function, what we do, and have that open engagement. So again, as well as questions, please do post any comments, any feedback, any other thoughts. Currently, the voting is split fairly evenly between direct feedback to supervisors and feedback questionnaires and surveys. Email and website, 14% of you have voted for that. I think probably final voting is direct feedback to supervisors at 38%. Feedback questionnaires and surveys, 47%. We're looking towards the end of the year at formally gathering feedback from those firms and individuals that we've been in contact with in supervision. If you're one of those firms or individuals, please do, prior to any formal feedback, let us know how that engagement's been. Any feedback's very much taken forward, so thank you. I think the voting's now remaining static. Direct feedback to supervisors, 38%, feedback questionnaires, 47%, and the rest email website. So thank you very much for voting. We'll now move on, and I'm going to hand over to my colleague Maria Walters, who will talk to you about the nomination process.
Thank you, Helen. I'm now going to talk through some slides, as Helen said, on the process itself. The nomination process has been split into 3 stages. The first stage of the process was commenced on the 31st of May when an email was sent out to all authorised signatories of firms. This email provided them with a link to a web-based form. Now, there are some authorised signatories who are also duplicated to other recognised bodies, and they may not have received their email yet. Please bear it with us. They should be coming to you in the next few days. If you haven't received your form by the web-based email by Monday, if you could email us on the email address I'll give you at the end of my presentation. The authorised signatory, once it's received the email, is required to complete the form, which in itself will confirm to us who the firm is nominating as its COLP and its COFA. The firm has to make suitable arrangements to make sure that they are in accordance with Rule 8.5 of the Authorisation Rules or 4.8 of the Practice and Regulations. They also need to provide us with the information that they are happy that the information they've given us on the individuals is accurate, that they have spoken to the nominees and they consent to their nomination, that the firm is satisfied that the COLP or COFA nomination is able to fully discharge their responsibilities as a COLP or a COFA of the firm, and finally that the information given within the application for approval of the firm's COLP and COFA nomination is correct. Once we receive the completed nomination form from the authorised signatory, the SRA will then forward an email to the COLP and the COFA, again attaching a link to the web-based form for them to complete their own declarations. The COLP will first of all receive their email. Once we receive the completed form back from the COLP will then receive their nomination form to complete. The declaration will ask them to confirm that they have first of all read and fully understood the requirements set out in the suitability test, And within the suitability test, you will notice some wording which refers to serious disciplinary action. It is for the SRA to decide if it's serious, so if there are any issues that they feel we should be aware of and they're not sure if it is serious, if they just let us know. If we feel it isn't serious, we will disregard it when we receive the information. Where appropriate, that they have discussed with the firm any concerns or issues they have regarding their own suitability to the role they are being nominated for, and that they are satisfied that they are able to fully discharge their responsibilities as set out in accordance with Rule 8.5 of the Authorisation Rules or 4.8 of the Practice and Regulations. It is not until we've received all three forms that we deem it to be a full nomination process from the firm. And the firms will have until the 31st of July in which to submit all three elements of the nomination process. When all three forms are received, authorisation will then complete their own checks. The check will come in the form initially of a verification check, and as Alex has already mentioned, we'll be looking at general background, criminal convictions, behaviours, assessments, financial history and regulatory history. We will be taking a risk-based approach, and we will obviously be considering all the information we already have about the firm and the individuals. Where a nomination has already declared character and suitability issues to us in the nomination form, or they are not known to the SRA, then we will be requiring additional information from them, which will include the completion, in some cases, of a suitability test, and we may also require them to supply a certificate of good standing for overseas nominations or a CRB check for UK nominees. In addition to this, we may find it appropriate for our supervision colleagues to make contact with the firms to make further investigations. Whilst we will be dealing with nomination forms as they are received, we will not be confirming any approvals during the nomination windows, and therefore you won't be expecting to receive any approval notification from the SRA before the 31st of July. This will allow us to review all the nominations in their entirety to highlight where the same COLP and COFA may have been nominated for multiple firms, to ensure that they have sufficient time and resource to fulfil the role in each firm. We will, however, ensure that where the nomination is to be refused by the SRA, the firm and the individual are advised as soon as possible to allow them to consider who they'd like to re-nominate. Once all nominees have been received by 31st July, we'll be making sure that we send all the approvals out by the 31st of December, ready for them to take up their new roles. Firms and individuals will be advised of this by email. Any firm that has not got a COLP or COFA in place by this date will be in breach. We've had a very good response so far already to our forms and emails, and we've had over 1,200 firms who've fully completed their nomination process, with a further 800 applications part completed. Our first application, which was full in respect of the authorised signatory nomination, the COLP and the COFA, was received within 5 minutes of the first email being sent out. For further information, you can find this on our website, which is www.sra.org.uk/compliance officers, or you can email us at complianceofficers@sra.org.uk. If you haven't received your email, you can also notify us through this inbox. Alternatively, you can call our contact centre on 0870 606 2555 or Professional Ethics Helpline on 0870 606 2577. So now I'll hand you back to my colleague Helen.
Thank you, Maria, and we'll leave those contact details up on the screen for you to note down, although as I said earlier, you can get the slides from our website. So that completes our presentation, which has covered the role of compliance officers, reporting requirements, the relationship between the SRA and the compliance officer community, and the nominations process. Now it's your opportunity to make any comments or ask us any questions, and you can do this by posting your question or comment in the question and answer box at the bottom of the screen. Alex, Maria and myself will read out those questions we receive and answer them accordingly. Certainly from our experience, last time we had an awful lot of questions. We weren't able to get through them all. We do take them all away, and we'll be looking at publishing FAQs on the website. So for those of you who perhaps don't get an answer to your particular question, we will be looking at publishing on the website. Again, remember that you can contact us with very particular specific queries. So we've got quite a few questions coming in. I think I'll take the first one. There's a question about the polls. Are the polls being counted as this is a repeat broadcast? Certainly the slides and the content is a repeat. The polling questions we thought were really useful and essential to having at this stage because we're constantly looking at the best way to engage with COLPs and COFAs in our regulated community. So we'll be taking that information away. Alex and myself as the supervision managers, we have a team of supervisors who are contacting firms direct. We're getting information in and we really need to know the best and most effective way to do that. So yes, we're certainly taking that information away and we'll then use that going forward in relation to our work with and our contact and communication with the regulated community. I think, Alex, you've now got a question.
Yes, there's a question about what the definition of lawyer is and does it include licensed conveyancers. Lawyer is defined in the Legal Services Act and you'll also find it in the definitions and glossary to the code in the October handbook, and licensed conveyancers are included within that. So lawyer is individuals such as solicitors, barristers, legal executives, licensed conveyancers and patent attorneys. So if you're not sure, you can check that definition in the code, but certainly licensed conveyancers come within the definition of lawyer and therefore can be nominated as a COLP.
Okay. Next question we have is, will an approved COLP or COFA for a regulated firm be automatically approved as a COLP for an ABS? The answer to this is no. Each time a COLP or COFA applies for a position in a new firm, they need to be reapproved. From a risk-based approach though, if the approval has just been completed for the recognised body and the firm applies for ABS, we will take a view of what elements of the process need to be revisited depending on the proposed changes to the firm. For example, if it's just an addition on a single non-lawyer manager in a small firm compared to a takeover of a large private equity fund.
Thank you, Maria. A question has come in on the COFA role. Can a COFA ever be external for the firm? I think Alex touched upon this because it's quite a common query. So individuals say that assist firms with their accounts and they may provide services to more than one firm. Well, firstly, this will depend on whether they fall within the definition of employee. Secondly, firms will need to consider if they have adequate time and resources and are sufficiently senior within the firm to fulfil those responsibilities. So certainly, in some cases, if those requirements are fulfilled, they can be a COFA.
Next question is about a firm that are a UK LLP, so they're practicing in the UK but also have a branch office in Paris. And it says that the Paris partners are partners in the UK LLP but are not UK solicitors. So does the FRA handbook apply to those lawyers and to the Paris office so that the principles and code of conduct apply to those partners in that office? Well, it does depend on the circumstances and the individual chapters and requirements within the code identify what applies to overseas practice. So whether or not those requirements apply to work done in the Paris branch will depend on different aspects of the code, but that's clearly set out at the end of each chapter in terms of what applies to overseas practice. Secondly, in terms of those lawyers, if they are partners in the LLP, or members rather, of the LLP, then the code and the handbook does apply to them, and they, for our purposes, are managers of that firm, even though they operate out of the Paris branch.
Next question then, is there a definitive job description for the COLP and COFA? No, there isn't a specific job description. However, from a firm's point of view, they need to be looking at the Rule 8.5 in the authorisation rules and define what responsibilities that, in their view, they feel the COLP and COFA should undertake.
Thanks, Maria. We've had a query in relation to the Firm B case study scenario, and that was in relation to the COFA. And the question is, why is that a matter for the COFA as it does not concern the accounts rules? So if you remember, the case study was around the financial viability and financial stability of the firm, and that doesn't tie direct to the accounts rules, is the query, because if you look back at the regulations, there's a specific reference to accounts rules. If I could just bring you to the accounts rules, Rule 1, particularly Rule 1.2, states you must comply with the principles set out in the handbook and the outcomes in Chapter 7 of the SRA Code of Conduct in relation to the effective financial management of the firm. And it then goes on to particularised requirements. So that then would relate back particularly to Principle 8, to run your business or carry out your role in the business effectively and in accordance with proper governance and sound financial and risk management principles. So that COFA role isn't discrete, focused purely on accounts rules in detail. Remember that 1.2 of the accounts rules broadens out the COFA's responsibility and those in the firm to complying with all of the principles set out in the handbook.
Okay, I've got another question. Paragraph 10.1c of the Suitability Test 2011 says, unless there are exceptional circumstances, we may refuse your application if any body corporate of which you are or were a manager or owner has been subject of a winding up order or administrative order or an administrative receivership, or has otherwise been wound up or put into administration in circumstances of insolvency. So if I was a director of a company 20 years ago and it has since gone into liquidation, must I show exceptional circumstances? There will be circumstances when I will have no idea that a company of which I was a director has been wound up. But if I do not tell you, this is prima facie evidence of dishonesty. When you do your nomination form, you're asked if there are any issues that you feel you should need to be aware of. We will send you out a form which will include the suitability test within it. It will be for you to disclose that information to us. We will look on it on an individual basis and we will look at what happened since that event, whether you're applying for the COLP or COFA at this point, and any other issues or regulatory history that we feel is appropriate. I can't say in this one instance as to whether or not we would or wouldn't consider this actual case, but we would look at it on its own merits.
Okay. Thank you, Maria. We've had several questions, and I think we did last time, about whether there'll be a reporting form available or a template. The quick answer to that is no. Remembering that outcomes-focused regulation is about flexibility, a move away from tick box regulation. We don't really want to be that formulaic in relation to reporting, because you might also want to pick up the phone and report that way, and we'll record it accordingly.
I mean, that leads into the next question, Helen, which is, as a sole practitioner who will be the COLP, as long as I conduct a file review, if the file hasn't been touched for 1 month to ensure that it's receiving proper attention, then have I discharged my COLP requirement in regards to that file? And it's the point that Helen just made there, that we're trying to move away from tick box compliance to firms and managers and compliance officers within the firm looking more carefully about whether the right outcomes have been achieved. So it would depend on the circumstances of that file, and what we wouldn't want is firms to be approaching file reviews and kind of ticking off that they've done that without considering the broader circumstances. So it may very well be your duties as a COLP discharged in those circumstances, but it would very much depend on the firm. The next question I've got is, if an employer is made a COFA, do they have to apply to be a recognised manager by the SRA? And no, that's not the case. For both a COLP and a COFA, the requirement is that they're a manager or an employee. So there isn't a requirement for the individuals to be managers as well, so long as they come within the definition of employer that we mentioned earlier, either through a normal contract or a contract for services.
One of the questions I've received as well is that someone hasn't received their nomination email. If you haven't received it by Monday, if you could email complianceofficers@sra.org.uk and let us know, and we'll look into that for you and arrange for one to be sent up to you.
Thank you, Maria. There's also a question in relation to training for compliance officers, and the query is around whether there's a formal requirement for compliance officers to attend training. There's no specific requirement in the authorisation rules or the handbook, but do have a look at outcome 7.6 of the code, which requires that individuals be trained to maintain a level of competence appropriate to their work and level of responsibility. So you might want to consider whether and what training is required. So for COFA's accounts rule training, If there are significant gaps in relation to accounts rule knowledge, obviously a one-day course may not be sufficient, but I think I referred earlier to support from the Law Society, and there are now lots of providers delivering training, so there's lots of opportunities out there to undertake training if you feel that is necessary and appropriate.
Thank you, Helen. Another question is, will this year's renewal form require a report on non-material breaches, given that the code is in place already, even if the COLP and COFA are not? And the answer to that is no. They'll be looking to report next year.
A quick query, is it possible to get these slides to train the firm staff? The slides are available on the website, as is the recording. All our webinars are on the website, you can hear them again. So please do use that facility and take that opportunity.
Next question is whether a non-lawyer partner in an ABS can be both COFA and COLP. Well, no, they can't be. There isn't anything preventing the same individual being both the COLP and COFA, so long as they meet the requirements for those roles. And in terms of the COLP role, the rules require that individual to be a lawyer. So a non-lawyer partner in an ABS wouldn't be able to be the COLP for the practice.
A question about COFAs, it really links back to one earlier. Can a COFA be a part-time employee? Again, there's no simple yes and no answer, because you need to think about whether there will be adequate time and resource for that person to undertake the role. So that's going to vary widely in relation to the type and the size of the firm, for example. And always remember, is that person sufficiently senior within the firm to fulfil their responsibilities?
Next question is about whether or not the COLP or COFA should have a deputy. So it isn't necessary to have a deputy, and it's important to remember that the SRA will only be authorising the role holder themselves. And this is one of the reasons why it's important for you to consider if the individual that's being nominated for the firm has sufficient time and resource to undertake the role. So, for example, it may not be appropriate for the senior manager in a very large city firm to be the COLP, as they're unlikely to have adequate time to fulfil the responsibilities of the role, and they cannot delegate those to others in the firm. What you might want to do, though, is think about compliance arrangements during holiday or sickness absence, but please remember that the overriding responsibility remains with the managers. And so following on from this, it's worthwhile considering the position if the COLP or COFA leaves the firm or is going to be absent for a considerable time, for example, going on maternity leave. And in those circumstances, the rule allows firms to submit an application for temporary recognition of authorised role holders when unexpected events occur. So in those circumstances, the firm could submit a substantive application thereafter to change the nomination.
Thank you, Alex. I think we're just going to take one more question now. Maria's going to answer that. But please remember, we'll be taking all of these questions away and looking to publish some useful information, perhaps some FAQs on the website. So Maria, could you take the final question, please?
Yeah, the final question is regarding waivers, and when would it, and what circumstances would a waiver be provided for a COLP and COFA? The answer is we can't really give you an exact circumstance as to when a waiver would be considered. It would be exceptional circumstances, and we take each case at its own merit. What I would say is whether there's a corporate body that doesn't do legal services, then potentially we would honour a waiver in that regard. Also, where you have a main office which may have other companies which are branch offices, we may look at the individual firm and where the reporting lines are and where the information and their sort of systems are based. What I would say is, if anyone is considering to actually apply for a waiver, then they need to contact our ethics helpline, who will give them more information on their own personal circumstances.
Thank you, Maria. We've now reached the end of our hour, the end of our webinar, and we really hope you found it useful. Thank you all for taking the time to join us today and for your input and questions. As mentioned, you can download the slides from our website, and we'd encourage you to make use of information on the SRA website. Remember those points of contact for us, so the ethics helpline, our supervisors, and the contact centre. So thank you once again. If you've got any further comments, do post them, and we'll look to take away those questions we haven't been able to answer and put some useful information on the website to assist people. So from myself, Alex and Maria, thank you for taking part.